Garcia was put on an airplane. He did not know where that airplane was flying to until it landed at the airport in El Salvador. What we're trying to do here is to make sure that that doesn't happen again a second time. The government has expressed that as soon as Mr. Abrego Garcia is released from criminal custody, which we are confident will happen next week, their intention is to redeport him to a third country. Which one? I don't know. It's now been 2 hearings at which they've reiterated that and stated that, and yet they've declined or said that they don't know which country. So for about the 5th or 6th time in this case, the government is trying the trick of sending its lawyers into court with inadequate information, with insufficient information, right? Under the Convention Against Torture, Kilmar Abrego Garcia has the right to not be sent to a country in which he will suffer torture, but also to not be sent to a country that will in turn immediately redeport him to El Salvador, where he will again be imprisoned and seek caught and tortured there in the manner that he described in his amended complaint. This time, Judge Zinnes was not willing to let the government lawyers get away with saying, we don't really know, we don't know where he's going to be sent, we don't know what the plan is. And so what she ordered is that on Thursday afternoon, a Department of Homeland Security official is going to have to come before this court and answer questions and tell the court what the actual plan is for Mr. Abrego Garcia. If they want to deport him to a third country, they need to name that country, and they need to describe the process by which they're going to give him due process, which is to say, an opportunity to state a defense, to raise a case before an immigration judge as to why he shouldn't be sent to whatever that third country is. If the government already has a plan for due process and they articulate that to the court, Judge Zinnes said, that's fine. Okay, I'll be fine with that. But if the government does not have a plan to provide Mr. Abrego Garcia with due process, then Judge Zinnes is going to have to order that he be given that due process. So all of that is in service of making sure that they don't do the same thing twice, which is to say, put him on a plane without any notice of where that plane is going. This is not a hypothetical fear. This is exactly what happened to the people who were sent to Libya. This is exactly what happened to the people who were sent to South Sudan. And the government considers that they can do this in any case. When we first picked up Mr. Abrego Garcia's case, we thought it was like a crazy, one-off, never going to be repeated type of situation. And what we learned in the months since then is it was actually just the tip of the spear. Hundreds upon hundreds of Marylanders who have prior grants of withholding of removal, right, who have previously won their cases in immigration court, are now being arrested by the Trump administration. In Mr. Abrego Garcia's case, they sent him to the one country they weren't allowed to send him to, El Salvador. That blew up in their face. They're not doing that anymore. And now what they're doing is this whole third country gambit, where they send people to really random third countries to which they don't have any connection to. And there have been dozens and dozens of lawsuits before this court, to the point that the Trump administration is suing this court to try to prevent this court from putting in place reasonable stays so that individuals like Mr. Abrego Garcia can't be deported to third country without even breathing room to file applications for protection. So what we thought was really just a one-off case has turned out to be actually really sort of the core of what the government is trying to do to remove people who previously won their cases, remove those people from the United States. We're not going to allow it to happen a second time to Mr. Abrego Garcia, just like we're fighting back in all of these other cases to prevent people who've been granted protection in this country from being removed to random third countries. And that's what this court is now going to have to decide in the case of Mr. Abrego Garcia.
Simon, Tom Fitzgerald from Fox 5. In court, U.S. Attorney said they couldn't tell what third country it would be. Do you believe them? Do they know where they want it, what they want to do, or are they just not telling the judge?
Since day one of this case, the government's strategy has been to send its lawyers into court with, no information or insufficient information, right? So when the Department of Justice lawyers say that they don't know where he's being sent to, that could be. But if that's the case, it's the result of a deliberate strategy by the Department of Homeland Security not to communicate with the lawyers who are going to.
you think they'll tell you on Thursday where they're going to send him? Where they plan to?
They're going to have to put a witness under oath. I don't think the judge is going to really put up with any prevarication.
If the concern is about what happens next, and I know he's set to be released next week in Tennessee, would you rather see Mr. Abrego Garcia remain detained in Tennessee if the concern is that he is picked up again and deported to some third country?
2 weeks ago, Mr. Abrego Garcia's criminal legal defense team needed to essentially file a request postponing the release out of Tennessee, just to give this court time to act, right? To give Judge Zinnes sufficient time to hold today's hearing. At today's hearing, she determined she needs an evidentiary hearing. You know, she's doing that on Thursday. It's an incredibly compressed time frame. I'm confident that she's going to rule on our motion to bring him to Maryland prior to July 16th.
So, Simon, just to be clear, then you believe when you said that you expect that his attorneys in Tennessee will drop their request that he be held in U.S. Marshals custody, that they will drop that request and then he'll be taken into ICE custody?
So the criminal attorneys in Tennessee requested that he be held in criminal detention in Tennessee through the next hearing in that case, which is on the 16th of July, which is next week. That's why we're asking this court to rule prior to the 16th of July on our motion, and what the motion is asking for is that when he be released from criminal custody in Tennessee, he be brought here into this building.
And if I can follow up, when the government said they're not going to, and they didn't use these words, but they're not going to pursue the criminal case if he's deported to a third country, what does that say to you?
Yeah, I don't really want to comment on the criminal case, but it was quite revealing at the start of the hearing when the government lawyer seemed to imply that the indictment was at least in part, sort of posturing in front of the government. That was a very interesting moment, but I'll leave comments on the criminal case to the criminal defense.
¿No nos puede explicar en español lo que espera para el jueves?
Por supuesto. La última vez que Kilmar Abrego García fue subido a un avión, él no sabía a dónde iba este avión, sino hasta que el avión aterrizó en el aeropuerto de El Salvador. Lo que estamos peleando ahorita es para que esto no vuelva a suceder. No a El Salvador, sino a un tercer país con el cual él no tiene ninguna conexión. Sería México, sería Libia, sería el sur de Sudán, sería algún otro país que ni siquiera hemos imaginado todavía. Lo que el gobierno está diciendo actualmente es que lo quieren enviar a un tercer país, pero no saben, supuestamente ni siquiera saben cuál. Entonces es la estrategia que han utilizado desde el principio de este caso, que es mandar abogados a la corte que no tienen información directamente de la agencia del Departamento de Seguridad Interna. Esta vez la jueza dijo que no está conforme con esto y por lo tanto ordenó que el jueves viene un alto oficial del Departamento de Seguridad Interna con conocimiento personal de cuál es el plan para Kilmar Abrego García. Ahora no van a poder esconder detrás de el jueves ya no van a poder esconder detrás de sus abogados. Un oficial va a tener que levantar la mano derecha y explicar exactamente, detalladamente, cuál es el plan para Kilmar Abrego García. A dónde lo quieren mandar, cuándo. Porque él tiene derecho de someter una aplicación para protección. Cualquier país que ellos nombren, tal como él sometió una aplicación para protección y ganó su caso a El Salvador, él tiene derecho a pelear un caso sobre cualquier otro país en el mundo. Pero él no puede hacer esto si no sabe cuál país es. Y el miedo es que o lo suben a un avión sin ni siquiera decirle a dónde va, o lo dan un papel diciendo a cuál país va prácticamente mientras lo estén subiendo al avión. Esto es lo que estamos luchando ahora para prevenir. Y lo último que quiero decir es que cuando iniciamos este caso con Kilmar Abrego García nos pareció un caso muy extraño, muy raro, muy fuera de lo común, sin sentido. Pero lo que nos dimos cuenta es que este caso realmente no era único, solo era el primero. Ya van cientos de personas aquí solamente en el estado de Maryland, cientos de inmigrantes que hayan ganado sus casos anteriores desde hace muchos años y ahora están siendo arrestados supuestamente para deportarlos a un tercer país. Entonces, lo que este corte falla en el caso de Kilmar va a ser de ayuda a todas esas personas que ganaron sus casos de suspensión de deportación anteriormente y que actualmente están completamente aterrorizados, que cuando van a su check-in con ICE o algo así, van a ser arrestados y deportados a un país que ni siquiera saben cuál es.
If
So
I
what
could,
is the best case scenario if he is released from jail and brought back to Maryland? And would that include he remains out of jail until the trial?
If he's brought, the purpose of bringing him before this courthouse is to put him in the ex-ante position, right? In the position he was before the unlawful arrest. As Judge Zinnes said, I think it was this is now the fourth hearing in which she's mentioned it. There was no warrant for his arrest. He was arrested completely without a warrant. Justice Sotomayor also raised that point in her concurrence in the Supreme Court case. If they want to take another run at it and do the process legally and correctly, we will defend that in immigration court. But the whole process was dirty and unlawful to begin with. And so it needs to be wound back, not just from the moment he was put on a plane to El Salvador, but from the moment in which they pulled over his car, right? And put handcuffs on him and took him into custody without any warrant, without any proper revocation of his supervised release. All of that was completely in violation of federal law, and they need to wind it back to before that happened. Then if they want to take a second run at arresting him and deporting him to some other country, as long as they do it following the law and following due process, they're welcome to do that, and we'll defend him in immigration court.
Simon, can you explain the judge's decision on the motion to dismiss as moot? Can you explain that?
Yeah, the government essentially argued in two motions to dismiss that since the original complaint, according to them, was only asking that he be brought back to the United States, and he's now back in the United States, this whole case is moot, and we're done here. We have no reason to come back to the courthouse. And the judge disagreed with that, and she denied those motions, and so the case continues. And again, as I mentioned, the reason the case continues is that he has not been put back in the position he was in before the first illegal act occurred. The first illegal act took place in College Park, Maryland, right? Not in South Texas when they put him on an airplane to El Salvador, but in College Park, Maryland, when they pulled over his car and put handcuffs on him without a warrant, without having properly revoked his supervised release.
¿nos puede decir esta parte en español, por favor?
El gobierno argumentó hoy de que como la querella inicial estaba pidiendo que lo trajeran de nuevo a Estados Unidos y ya él está nuevamente en Estados Unidos, entonces el caso ya básicamente se cumplió y no hay razón para seguir un caso. El caso se puede votar, no tenemos que volver a esta corte ya, porque ya se cumplió lo que tenían que hacer. Pero la jueza no estuvo de acuerdo y lo que ella falló es que el caso sí tiene que seguir. Y lo que tiene que seguir es que el acto ilegal, el primer acto ilegal en el caso de Kilmar Abrego Garcia, no era subirlo a un avión, sino 2 o 3 días antes arrestarlo aquí en Maryland sin una orden judicial y sin haber revocado su orden de supervisión de una manera legal. Entonces, por lo que él no está nuevamente aquí en Maryland, donde él estuvo antes de los actos ilegales del gobierno, el caso sigue vigente.
The Supreme Court gave you a majority opinion at your back. How's that affecting your litigation here?
Yeah, I mean, that's why we're here, right? The Supreme Court ruled 9-0 that the government needs to put him back in the position that he was in before he was unlawfully removed to El Salvador. And a 3-judge concurrence led by Justice Sotomayor explained very specific federal regulations that includes. It includes the federal law that says you can't be arrested without a warrant unless there's, like hot pursuit and reason to believe the person's going to escape. This is an individual who is on a regular check-in schedule with ICE. They have no need to arrest him without a warrant. Federal regulations require that if they're going to revoke an order of supervision, they have to go through certain legal process. Supervised release, they have to go through certain legal processes first. They didn't do that here, right? So all of those things need to be restored. He needs to be restored to his order of supervised release because it was never properly revoked.
So again, what's the status of that withdrawal, removal, that initial status that allowed him to be here?
Yeah, he's still very much got an order of withholding of removal to El Salvador. The government concedes that they can't send him to El Salvador again without taking him back before an immigration judge. But the real dispute here is whether they can send him to some random third country without taking him back before an immigration judge. The government says they can. They say they can just put him on a plane, right? And he can figure out where that plane's going to, either when it lands or shortly before it takes off, and have no opportunity to file protection as to whatever that country is. Our contention is that both the immigration laws and the Constitution require notice and opportunity to be heard. Ultimately, it's going to be fought out in front of an immigration judge, right? It's not going to be this court that decides whether he can or can't be sent to Mexico, or Libya, or South Sudan, or what have you. But what this court needs to give him is advance notice and some breathing room to be able to file an application for protection.
There were 4 motions today, and forgive me, I can't tell the players without a program. Were they all ruled on? Were 2 of 4 ruled
Two
on?
motions to dismiss, government motions to throw out the case, both of those were denied. There was our motion to have him be brought back to Maryland. That's what the judge is going to take evidence and testimony on Thursday, and then hopefully we'll decide it either right then and there based on the testimony or shortly thereafter. I am confident she'll decide it before the 16th. And then there's our motion to amend the complaint, which is really just sort of to update the facts since the complaint was filed several months ago. And the judge set forth a briefing schedule on that motion.
And that's the one that includes the treatment he had in
Correct.
CCOT custody.
Kyle, you said, Simon, you said in court that you found out that your father was on a plane to El Salvador from ABC News.
That he'd been brought back from El Salvador.
That he'd been brought back from El Salvador.
Yeah, I mean, that just goes to show that the government's been playing games with the judicial process throughout this entire experience, right? I mean, instead of advising the court, they could have filed an under seal filing. They could have, right? They didn't do any of that, right? Then if it was under seal, you wouldn't have known. I wouldn't have known about it. You wouldn't have known about it. But they didn't. Instead, they chose to announce it to the court by means of a press conference at the Department of Justice. Right? That not only was the first that I heard about it, it was also the first that someone heard about it. Can't imagine she was pleased about it.
Any final questions, folks?
Thank you.
Very much.
Thank you all.
Thank you.
Thank you so much for being here. As we said earlier, the fight continues. We're going to be right back here on Thursday afternoon, y'all. Have a great rest of your day.